Good afternoon, everyone. I am presenting my constitutional law internal assignment on the topic judicial activism in environmental jurisprudence in India. We live in an age of environmental crisis. In India, rivers are polluted, forests are shrinking, and air quality in our cities has reached alarming levels. You would expect our environmental laws to provide a strong answer, and they do, but completely not. Always because Parliament acted, very often it is our courts that have stepped in. The Indian The Indian Constitution, when adopted in 1950, had no direct provision guaranteeing citizens a clean and safe environment. Yet today, the right to a healthy environment is a fundamental right. How did this happen? The answer is judicial activism. Over the next 8 minutes, I will walk you through what judicial activism means, which constitutional provisions the courts have used, the four major doctrines they have developed, the landmark cases that transformed our environmental law, and a critical evaluation of this approach. So, what exactly is judicial activism? Judicial activism is the tendency of courts to go beyond the literal text of law and to actively protect rights, filling the gaps that the legislature has left open. The term was coined by American historian Arthur Jr. in 1947. So, what exactly is judicial activism? Judicial activism is the tendency of courts to go beyond the literal text of law and to actively protect rights, filling the gaps that the legislature has left open. The term was coined by American historian Arthur in 1947. In India, Justice V.R. Krishna Iyer described the judiciary as watchful of violation of fundamental rights. The primary tool of judicial activism in India is PIL. Any member of public can approach the Supreme Court or High Court to enforce a public right, even if they are not personally affected. This was revolutionary because traditional law required you to be a aggrieved party. PIL removed the barrier and opened the courts to NGOs, activists, and ordinary citizens for fighting for the environment. Without PIL, most of the environmental cases would never have reached the Supreme Court. Now, where do courts find constitutional authority to protect the environment? The three key provisions are: first, Article 21, the right to life. This is the most powerful provision. The Constitution says no person shall be deprived of his life except by procedure established by law. It says nothing about the environment, but the Supreme Court in Subhash Kumar vs. State of Bihar held that the right to life includes right to live in a pollution-free environment. A life without clean air and water is not meaningful. Secondly, Article 48A inserted by 42nd Amendment. Second, Article 48A inserted by 42nd Amendment in 1976 directs the state to protect and improve the environment. While it is a directive principle and thus not directly enforceable, uh, courts use it to guide interpretation of Article 21. Third, Article 51AG, inserted in 1976, makes it a fundamental duty of every citizen to protect the natural environment. Courts have used this to hold polluting industries constitutionally accountable. Through their decisions, Indian courts have developed four major environmental doctrines. These are not found in any statute. They are entirely judge-made law. First, the precautionary principle. If there is a reasonable threat of serious environmental harm, you cannot wait for complete scientific proof before acting importantly. This shifts the burden of proof. It is the developer or industrialist who must prove their activity is safe, not the public, that must prove it is dangerous. Second, the polluter pays principle. Whoever Whoever pollutes must pay, not just for cleanup, but for all the damages caused to the community. The cost of pollution cannot be passed on to the society. Let me walk you through the six landmark cases that build the Indian environmental jurisprudence. Sorry. Uh, यहाँ से बोलूँ क्या? Case 1, Rural Litigation and Entitlement Kendra versus State of UP, 1985. The Dehradun quarrying case. Limestone quarrying in the Mysore Hills were destroying natural springs and causing landslides. The Supreme Court, exercising Article 32, ordered the closure of quarries, one of the first times an Indian could shut down industrial activity on environmental grounds. It established that PIL is maintainable in environmental matters. Case 2, MC Mehta versus Union of India, 1987, the oleum gas leak case. When gas leaked from the Shriram fertilizer plant in Delhi, the Supreme Court created the doctrine of absolute liability. Unlike the English rule of strict liability, which allows defenses, absolute liability means industries engaged in hazardous activities have no defense whatsoever. They must compensate periodically. Case 3, MC Mehta, 1998, the Ganga pollution case. Kanpur tanneries were discharging untreated waste into the Ganga. The court ordered them to stop functioning if they could not set up treatment plants. Economic hardship was held to be no excuse for polluting a river that millions depend upon. Fourth case, Vellore Citizens Welfare Forum versus Union of India, 1996. Tamil Nadu tanneries were destroying the river. The Supreme Court constitutionalized the precautionary and polluter-based principle, holding they form part of the Indian constitutional law. The fifth case, Indian Council for Enviro-Legal Action versus Union of India, 1996. Chemical industries rendered an entire village uninhabitable. The court applied the polluter pays principle and directed full remediation uh, at the industry's expense. Judicial activism in environmental law has clear advantages. It has filled the gap left by the legislature inaction, democratized access to justice through PIL, constitutionalized environmental rights, and developed innovative doctrines. But there are legitimate criticisms too. Courts are not expert environmental regulators. They lack the technical knowledge to prescribe emission norms or industrial process. There is a risk of judicial overreach violating the separation of powers, and the PIL itself has been misused, as in the Subhash Kumar, where the petitioner was found to have private motive, not a genuine public interest. The greater limitation is this: a court order is not only as effective as its enforcement. Many Supreme Court environmental directions remained unimplemented because the court depends on the very executive agencies it is trying to control. The public trust doctrine: natural resources, air, water, forest, river belong to the public. The state holds them in a trust and cannot give them away to private parties for commercial exploitation. Sustainable development must not compromise the ability for future generations to meet their own needs. Economic growth and environmental protection are not opposites, they must be balanced. All four of these doctrines were drawn from international law and built into our constitutional framework by the Supreme Court. To conclude, the Indian judiciary has done something remarkable. Starting from a constitution that said almost nothing about the environment, it has built one of the most progressive bodies of environmental law in the world entirely through creative constitutional interpretation. Article 21, Article 48A, Article 51AG. Through these provisions, the Supreme Court has said to every citizen and every industry, you have a constitutional duty to protect this environment, and if you do not, the courts will intervene. But judicial activism is a supplement, not a substitute for a legislative and executive action. The challenge for our generation is to take the rights the judiciary has created and embed them in a functioning, well enforced system of environmental governance. Thank you.